I'm sure you've come across the term copyrights, but do you truly understand what it means? From those of you who run your own business, have you taken steps to safeguard yourself from possible copyright violations, whether they involve your own creative work or the creation of others? I'm L.A. Perkins, a brand protection attorney. I help business owners and entrepreneurs identify and protect their intellectual property assets so they can avoid costly mistakes and increase the value of their business in the long term. I make videos like this educating business owners from small to large industries on how to protect their intellectual property assets. So check out some of my other videos on my website and my YouTube channel and like, subscribe, and share. In this video, I'm going to explain what a copyright is, or what it means, and why it's important for you to understand this as a business owner. So, what is a copyright? A copyright protects the works of authorships that are fixed in any tangible form or medium of expression, original in the sense that it was independently created by the authors or the author, and at least minimally creative. Something to know about copyrights is that you have a copyright from the moment that the work of art is created. You actually have a copyright. That is a common law copyright. Whether or not you share the work with anybody, so it could be published or unpublished, you still have a copyright in that creative work that you created. A copyright registration is something that is different, and we'll talk about that a little later in this video. So there are various examples of forms of copyrighted work, such as literary works, which includes books, manuscripts, films, computer programs; musical works, which includes accompanying words; dramatic works, which includes the accompanying scripts, music, and screenplays. Pantomimes and choreographic works are also copyrightable. Pictorial, graphic, and sculptural works, which include fine, graphic, and applied art, art reproductions, photographs and prints, maps, models, and technical drawings. And they also include motion pictures, video games, and other audiovisual works. There are some items that are not protected by copyright, and those items include ideas, systems, methods, or processes, United States government works, and typefaces, although a program that creates creative typefaces would be copyrightable. So it's very important for a business owner to understand some of the basics about copyright law so they can make sure that they have the necessary controls in place to be able to protect their creative work from others using it, as well as making sure that they don't infringe on other people's copyrighted work. You may also be wondering, who is the author of the copyrighted work? Oftentimes, businesses hire other people to do work for them, and then there's an issue as to who owns that work and who is the author of that work. So one thing to know is that the author may be one or more persons, and in the event that there's more people, the work is jointly owned. Unless, of course, there's a contract that specifies otherwise. For a work made for hire, the employer is the initial owner of the copyright. But that's where sometimes things get a little bit tricky, so it's always good that if you're engaging someone to do something creative for your company, that you make sure that you, as the owner of that company or your company, owns all the rights, unless either of the people who worked on the project agree differently and put that in writing. So you may be wondering, how long does copyright protection last? Generally, for works created after January 1st, 1978, copyright protection lasts for the life of the author plus an additional 70 years. Generally, for works published after 1923 and before 1978, copyright protection lasts for 95 years from the date of publication. When a copyright expires, the work becomes part of the public domain. And what that means is, after the copyright is expired, you can use the work without being subject to infringement. But please note that patent or trademark law may still apply. So you're probably familiar with seeing the copyright symbol. Unlike in trademark law, where you have to register your trademark with the United States Patent and Trademark Office before using the R in a circle, when a work is created, the owner of the work can use a C in the circle to claim ownership without registration. However, there are benefits to registering your work and obtaining a copyright registration through the United States Copyright Office. And some of those benefits include, in the event that you need to enforce your copyright and stop another party from infringing by using your work, in order to file a lawsuit in federal court, it's required that you have a copyright registration. In addition, once you have a copyright registration, you also have the ability to get statutory damages. Now, statutory damages can range anywhere from $750 for a violation up to $30,000, and if there's willful infringement, it can go up to $150,000. And it's really helpful to be able to get statutory damages, because then you have a choice of choosing the statutory damages versus proving up the damages and how you were actually impacted by the copyright violation, which sometimes is hard to do and costly. In addition, when you have a copyright registration, you have the ability to get attorney's fees. If you don't have a copyright registration and you're looking to just stop someone from the unauthorized use of your work, you will not be able to obtain attorney's fees, of course, unless they agree to give them to you. Without a copyright registration, you cannot file a lawsuit in federal court. Let's say there's an infringement. Someone has infringed your copyright and you want to stop them, but you don't have a copyright registration. Well, it's a good idea at that point to call an attorney that can help guide you, because time is of the essence. You may want to, at that point, proceed with filing a copyright application and request that you get the registration on an expedited basis. Now, by doing it on the spot like that, where you need the registration immediately or as quickly as possible, it's going to cost more money. There are increased fees to the Copyright Office, and there are increased fees to the lawyer having to deal with it versus having filed for the copyright registration when you didn't have a dispute at issue. So one of the things I want to make sure that you understand, there seems to be a misconception that if an image is located or is accessible online, that you can use that image. You can copy that image and use that image for your own purposes. And that is not true. That, unfortunately, can result in a copyright infringement violation. I have helped numerous clients that have received cease and desist letters because they unknowingly were using work that they were not authorized to use, and now the owner of that work was demanding thousands of dollars. I've also been on the other side where I represent clients that have registered copyrights, and they come to me because they find out that other businesses are using their protected copyrighted work. And that results in us generally sending a cease and desist letter to the party with the ability to claim thousands of dollars in damages. It is very clear that copyright law is highly misunderstood by the public. And that is why it is so important for you as a business owner to make sure that you understand the fundamentals. Do you know if you're protected from copyright infringement? Or is someone possibly infringing on your copyright? If you are a business owner with any intellectual property and you're curious whether you are protected, please reach out. We can schedule a complimentary consultation and put together a plan of action moving forward. I hope that this video helped you gain an understanding as to what a copyright means and why it's important to know about it so that you can protect your business. Feel free to comment on this video below and make sure to watch my other videos so you can learn how you can protect your brand assets. Call my office today. I'm L.A. Perkins, and I look forward to helping you get your brand armor on.